Real property. From the Barbri outline. Part 7. Security interest in real estate. Page 136. A. Types of security types of security interest. The security interest in real estate operates to secure some other obligation, usually a promise to repay a loan, which is represented on a promissory note. If the loan is not paid when due, the holder of the security interest can either take title to the real estate or have it sold and use the proceeds to pay the debt with accrued interest and any legal and court costs. Of the 6 types of security interest, the first 3 are most important. 1. Mortgage. 2. Deed of trust. 3. Installment land contract. 4. Absolute deed, equitable mortgage. 5. Sale leaseback. And 6. Equitable vendor's lien. Mortgage. Number 1. The debtor note-maker is usually the mortgagor. He gives the mortgage along with the note to the lender, who is the mortgagee. But note that the debtor and mortgagor can be different people. For example, a mother agrees to place a mortgage on her house to secure a loan to her daughter. Most states require that a lender realize on the real estate to satisfy the debt only by having a judicial, court-ordered foreclosure sale conducted by the sheriff. Number 2, deed of trust. The debtor note-maker is the trustor. The trustor gives the deed of trust to a third-party trustee who is usually closely connected with the lender, for example, the lender's lawyer, affiliated corporation, or officer. In the event of default, the lender, termed the beneficiary, instructs the trustee to proceed with foreclosing the deed of trust by sale. Many states allow the sale to be either judicial, as with a mortgage, or non-judicial under a power of sale clause that authorizes the trustee to advertise, give appropriate notices, and conduct a sale personally. 3rd, installment land contract. In an installment land contract, the debtor is the purchaser of the land who signs a contract with the vendor, agreeing to make regular installment payments until the full contract price, including accruing interest, has been paid. Only at that time will the vendor give a deed transferring legal title to the purchaser. In case of default, the contract may contain a forfeiture clause providing that the vendor may cancel the contract, retain all money paid to date, and retake possession of the land. However, the defaulting purchaser may be entitled to restitution to the extent his payments exceeds the vendor's damages. Absolute deed, equitable mortgage. 4th type of interest in security. Security interest in real estate. A landowner needing to raise money may sell the land to a person who will pay cash and may give the buyer an absolute deed rather than a mortgage. This may seem to be safer than a mortgage loan to the creditor and may seem to have tax advantages. However, if the court concludes by clear and convincing evidence that the deed was really given for security purposes, they will treat it as an equitable mortgage and require that the creditor foreclose it by judicial action, like any other mortgage. This result will be indicated by the following factors. Romanet 1, the existence of a debt or promise of payment by the deed's grantor, and Romanet 2, the grantee's promise to return the land if the debt is paid, and Romanet 3, the fact that the amount advanced to the grantor-debtor was much lower than the value of the property. Romanet 4, the degree of the grantor's financial distress, and Romanet 5, the parties' prior negotiations. Defines absolute deed - equitable mortgage. And 5th, a sale leaseback. A landowner needing to raise money may sell her land to another for cash and may then lease the land back for a long period of time. As in the case of the absolute deed, the grantor lessee may attack such a transaction later as a disguised mortgage. Factors that will lead the court to such a result are Romanet 1. The fact that the regular rent payments on the lease are virtually identical to payments that would be due on a mortgage loan. Romanet 2. The existence of an option to repurchase by the grantor lessee. And Romanet 3. The fact that the repurchase option could be exercised for much less than the probable value of the property at that time, so that the repurchase would be very likely to occur. And 6. Equitable vendor's lien. In addition to an installment contract and a purchase money mortgage, a seller may finance the buyer's purchase of the land by an equitable vendor's lien. The lien does not result from an agreement, but rather arises by implication of law when the seller transfers title to the buyer and the purchase price or a portion of the purchase price remains unpaid. So those are 6 types of security interest in real property: mortgage, deed of trust, installment land contract, the most important 3, followed by absolute deed - equitable mortgage, sale leaseback, and equitable vendor's lien. Part B, transfers by mortgagee and mortgagor. All parties to a mortgage deed of trust can transfer their interests. Ordinarily, the mortgagor transfers by deeding the property, while the mortgagee usually transfers by endorsing the note and executing a separate assignment of the mortgage. The note and mortgage must pass to the same person for the transfer to be complete. Transfer by mortgagee. A transfer of mortgage without note. The case law is divided, with some states holding that the transfer of the mortgage automatically transfers the note as well, unless the mortgagee transferor expressly reserves the rights to the note, which there would rarely be any reason for the mortgagee to do. In these states, the transferee of the mortgage can then file an equitable action and compel a transfer of the note as well. Other states hold that because the note is the principal evidence of the debt, a transfer of the mortgage without the note is a nullity and is void. B. Transfer of note without mortgage. The note can be transferred without the mortgage, but the mortgage will automatically follow the properly transferred note unless the mortgagee transferor expressly reserves the rights to the mortgage, which there would rarely be a reason for the mortgagee to do so. No separate written assignment of the mortgage is necessary, although it is customary for the transferee to obtain and record an assignment of the mortgage. Methods of transferring the note. The note may be transferred either by endorsing it and delivering it to the transferee, or by a separate document of assignment. Only if the former method is used can the transferee become a holder in due course under UC Article 3. Holder in due course status. A. To be a holder in due course of the note, the following requirements must be met. The note must be negotiable in form, which means that it must be payable to bearer or to the order of the named payee. It must contain a promise to pay a fixed amount of money, although an adjustable interest rate is permitted, and no other promises, except that it may contain an acceleration clause and an attorney's fee clause. 2. The original note must be endorsed, i.e. signed, by the named payee. Endorsement on a photocopy or some other document is not acceptable. And 3rd, the original note must be delivered to the transferee. Delivery of a photocopy is not acceptable. And 4, the transferee must take the note in good faith and must pay value for it. Value implies an amount that is more than nominal, although it need not be as great as the note's fair market value. The transferee must have any notice that the note is overdue or has been dishonored, or the maker has any defense to the duty to pay it. And B. Benefits of holder in due course status. A holder in due course will take the note free of any personal defenses that the maker might raise. Personal defenses include failure of consideration, fraud in the inducement, waiver, estoppel, and payment. The holder in due course is, however, still subject to real defenses that the maker might raise. These include infancy, other incapacity, duress, illegality, fraud in the execution, forgery, discharge, and insolvency, and other insolvency. Effective payment to original mortgagee after transfer of note. Under the version of the UCC enacted in a large majority of states, if the original payee transfers possession of the negotiable instrument, a payment to the original payee will not count, and the holder of the instrument can still demand payment. However, many notes secured by mortgages on real property are not negotiable in form, because their promise to pay is conditional and they are not payable to bearer or order. If the original mortgagee transfers possession of a non-negotiable note, the original payment to the original mortgagee is effective against the transferee until the mortgagor receives notice of the transfer. And it's funny, it's got this cited as the restatement third of property mortgages section 5.5, and it's also part of banking regulations. So a borrower example, A borrows $50,000 from B and gives B a non-negotiable note for that amount, secured by a mortgage on Blackacre. 1 year later, B assigns the note and mortgage to C, transferring actual possession of the note to C. 2 years thereafter, A, who does not realize that B no longer holds the note, pays $50,000 plus interest to B. This payment is effective against C. C's recourse is against B. Transfer by mortgagor. Grantee takes subject to mortgage. If the mortgagor sells the property and conveys a deed, the grantee takes subject to the mortgage, which remains on the land, unless there is a specific clause in the mortgage that the mortgagee has no power to object to the transfer. Assumption A, non-assuming grantee B, and due on sale clauses C. So A, assumption. Often the grantee signs an assumption agreement promising to pay the mortgage loan. If she does so, she becomes primarily liable to the lender, usually considered a third-party beneficiary, while the original mortgagor becomes secondarily liable as a surety. Note, however, that the mortgagee may opt to sue either the grantee or the original mortgagor on the debt. If the mortgagee and grantee modify the obligation, the original mortgagor is completely discharged of liability. Non-assuming grantee. A grantee who does not sign an assumption agreement does not become personally liable on the loan. Instead, the original mortgagor remains primarily and personally liable on the loan. Instead, the original mortgagor remains primarily and personally liable. However, if the grantee does not pay, the mortgage may be foreclosed, thus wiping out the grantee's investment in land. Due on sale clauses. Most modern mortgages contain due on sale clauses which purport to allow the lender to demand full payment of the loan if the mortgagor transfers any interest in the property without the lender's consent. Such clauses are designed to both Romanet 1. Protect the lender from sale by the mortgagor to a poor credit risk or to a person likely to commit waste, and Romanet 2. Allow the lender to raise the interest rate or charge an assumption fee when the property is sold. Federal law preempts state law and makes due on sale clauses enforceable for all types of institutional mortgage lenders on all types of real estate. The preemption does not apply to isolated mortgage loans made by private parties. C. Defenses and discharge of the mortgage, and D. Possession before foreclosure.